Sir, step away from the entrance. This area is not for general public access.
I am aware of that. I have an appointment inside.
What kind of appointment? The kind that has been on the federal visitor authorization list since last Thursday.
Sir, are you lost? Do you need me to call somebody for you?
What I need is for you to step aside. Sir, you can't go in there.
I have every right to be here.
Sir, please stop.
I don't think so. No. Son, I sat on that bench for 31 years. Touch me and you will spend the rest of your career explaining why.
Sir, I am telling you for the last time. Back up or I will place you under arrest.
On what charge?
Failure to comply with lawful
The
order.
United States District Court authorized me 9 days ago, in writing,
I don't see any letter.
because you have not asked for one.
This
Ask.
entrance is restricted. You cannot be here.
I have been coming through this entrance for 4 decades. I assure you I can.
Nobody authorized you to use
It is
this
a courtesy. A last one I intended to offer. Pick up that radio, run my name, then stand very still and listen till it comes back.
Yes, sir. I'm going to need you to back up right now or I will detain you for trespassing.
Son, you should think very carefully before you do that.
Is that a threat?
Officer Travis Kowalski had been with the Houston Police Department for 6 years. He was 29 years old. He had never once in those 6 years been made to feel wrong about a snap judgment he had formed in the first 3 seconds of encountering someone. His supervisors rewarded confidence. His precinct culture rewarded decisive action. His career had been built on the assumption that his instincts were reliable tools of law enforcement. They were not. What Kowalski saw when he looked at Dr. Raymond Ellington Hayes was an elderly black man, 70 years old, moving slowly but deliberately toward the entrance of the Bob Casey United States Courthouse on Rusk Street in downtown Houston. Dr. Hayes was wearing a charcoal gray suit pressed with military precision. He carried a leather briefcase that had been with him for 22 years. He walked with the unhurried certainty of a man who had never once in his adult life needed to rush to prove that he belonged somewhere. Kowalski did not see any of that. He saw an old man approaching a door he was not supposed to use, and his instincts told him to intervene. Let me tell you who Dr. Raymond Ellington Hayes actually was, before I tell you what happened next. Because who he was is the entire story. Dr. Hayes was born in Beaumont, Texas, in 1954. He attended segregated elementary schools before integration reached his district, meaning his early education happened in underfunded buildings with secondhand books, while white children 2 miles away received newer copies of the same texts. He watched his mother grade papers by lamplight at the kitchen table because the school did not pay her enough to keep all the lights on. He learned from that table that the mind was the one thing no institution could underfund if you refused to let it. He attended Texas Southern University on a full academic scholarship, graduated summa cum laude in 3 years, and went on to the University of Texas School of Law, where he was one of 11 black students in his entering class, and one of 4 who graduated. He clerked for a federal district judge who told him in his first week that the law was a tool, and the question of a lawyer's life was always going to be what he chose to use it for. Dr. Hayes used it for 31 years on the federal appellate bench. He was appointed to the Fifth Circuit Court of Appeals in 1988. In 1991, he wrote the majority opinion in Harmon v. City of Dallas, establishing the controlling precedent for unlawful detention in racial profiling cases across Texas, a standard that has been cited in over 300 subsequent cases and remains in force to this day. He retired in 2019. He did not stop working. He consulted, testified, taught, and mentored. He was not a man who had learned to stop. On the morning of the incident, he had left his home in Houston's Museum District at 8:15, reviewed his expert witness materials over breakfast, kissed his wife Eleanor on the cheek, and driven the Lincoln Continental he had owned for 9 years to the courthouse garage he was authorized to use. He had made that same walk from the garage to the Rusk Street entrance perhaps 300 times. He was stopped on this particular Tuesday morning in July by a 29-year-old officer who looked at 300 prior visits, 31 years on the federal bench, and a lifetime of legally transformative work. And the first thing he said was, "Are you lost? My name is Dr. Raymond Ellington Hayes. I'm expected inside at 9 o'clock. Do you have an ID?" Of course I have identification. I also have a letter from the United States District Court confirming my appointment as expert witness in the Whitfield Crane proceeding. I would like to get inside. Call courthouse security. Ask for Marshal Christine Webb. She will confirm everything I just told you inside of 90 seconds. Sir, I decide how I conduct this verification. Then conduct it, but conduct it quickly because I am 70 years old and I have been standing in the Texas heat while you decide whether I look like the kind of man who belongs in a federal courthouse. Watch your tone. I have watched my tone for 7 decades. My tone is fine. Your procedure is the problem. You're being uncooperative. I am being precise. There is a difference, and at your age you should already know it. That's it. Step back right now, or I am placing you under arrest for failure to comply with a lawful order. There were 7 people within clear sightline of the entrance. A federal agency staff attorney who recognized a courthouse entrance stop when she saw one. A law firm courier who had delivered to this building twice a week for 2 years. The food cart vendor who had worked that corner since 2013, and a retired school teacher named Ms. Dorothy Pruitt, 68 years old, on her way to a Social Security hearing on the 4th floor, who stopped, not because she knew who Dr. Hayes was, but because she knew exactly what she was looking at. Ms. Pruitt would later write in her witness statement, "I know the difference between someone acting suspicious and someone standing dignified while being treated with disrespect. That man was standing dignified. The officer was the one acting without control." Dr. Hayes placed his briefcase on the ground with deliberate care. He straightened to his full height. He was not imposing through size. He was imposing in the way that comes from 31 years of commanding a federal courtroom. His stillness was its own kind of authority. "I am not going to be arrested. I am going to tell you one more time who I am. And then I am going to suggest very strongly that you pick up that radio and call your supervisor. Not because I need help, because you do." Kowalski stepped closer. The staff attorney took out her phone. The food cart vendor did the same. "I said step back, and I said call your supervisor. Let me tell you something about the building you are standing in front of." Dr. Hayes's voice had not risen. If anything, it had dropped, the way the temperature drops before a storm. The Bob Casey United States Courthouse houses the Southern District of Texas. The judges inside have authority that supersedes every state and local law enforcement body in this region. I am not telling you this to impress you. I am telling you because you are making a decision that is going to have consequences you have not thought through. And I am trying, in spite of everything happening here, to give you a chance to think through them. You think I'm scared of some old man's speech? I think you are scared of your own uncertainty, and you are covering it with aggression. I watched it in my courtroom for 3 decades. Son, I am giving you an opportunity. Take it. The last person who gave me an opportunity was my first-grade teacher. Then you have gone a long time without accepting one. Call your supervisor. Tell them you have a man outside who says he is Dr. Raymond Ellington Hayes, and he has been appointed as an expert witness in the Whitfield Crane proceeding. Just say that. Say those words, and wait for the response. Why would I do that? Because the response is going to change the rest of your morning, possibly the rest of your career. My name is not ordinary. Run it. You have a radio. You have a database. Run the full name, Raymond Ellington Hayes. All 3 names. And then look at what comes back. Kowalski hesitated. Just a fraction of a second. The staff attorney caught it. The food cart vendor caught it. Dr. Hayes, who had watched witnesses on the stand for 3 decades and learned to read every micro-expression a human face could produce, caught it completely. You might also want to ask courthouse security what time my name appeared on the visitor authorization list. It has been there since last Thursday. The clerk's office processed my appointment letter 9 days ago. You're stalling. I am standing still in the heat at the age of 70. That is more patience than most people would extend to this situation. I am not stalling. I am informed. Kowalski grabbed his radio. Dispatch, I have a subject at the Rusk entrance claiming to be an expert witness. Says he's on a visitor authorization list. Name is... He looked at Dr. Hayes with an expression that carried the faint assumption he was about to catch him in a lie. What did you say the name was? Raymond Ellington Hayes. Dr. Raymond Ellington Hayes. The honorific matters in this context. Use it. Kowalski repeated the name on the radio. He did not use the honorific. The radio crackled. A pause. Another crackle. Then dispatch came back, with something that was not a routine confirmation. The voice was measured, but there was something different in it. Something careful. Can you repeat that name? Hayes. Raymond Hayes. Subject claims to be an expert witness. Another pause. Longer. Kowalski, are you at the Rusk entrance? Affirmative. Stand by. Kowalski looked at Dr. Hayes. Dr. Hayes looked back at him with an expression that communicated nothing except patience. Stand by means stand by. We can wait. If you have ever stood somewhere you had every right to be and been made to prove it to someone with a fraction of your experience, drop the word standing in the comments. What Dr. Hayes did in that moment, the refusal to shrink, the willingness to wait with complete dignity, that is something only certain people understand. Let us know you are one of them. They waited. 14 seconds. Which is a long time to stand in silence when dispatch has just told your officer to stand by in a tone that suggested things were considerably more complicated than he had made them. On the 6th floor, inside the chambers of Judge Loretta Hines Batiste, a clerk knocked and said, Your Honor, there is an officer at the Rusk entrance who appears to have stopped Dr. Hayes. The judge looked up from her papers. She said, I'm sorry, what? The clerk repeated it. Judge Hines Batiste picked up her phone. Captain Sandra Odom had been with HPD for 24 years. She had learned over those years that the calls requiring her personal presence were rarely as simple as the officer on scene believed they were. She arrived at the Rusk Street entrance 4 minutes after being called. She stepped out and assessed the scene before she reached the sidewalk. She saw a young officer with his chest forward and his jaw tight. She saw witnesses, with phones raised. She saw a man standing at the courthouse doors with a briefcase at his feet and his hands clasped behind his back, the posture not of a suspect, but of a man waiting out an inconvenience with the absolute certainty that it would resolve in his favor. She saw the suit, the pressed collar, the gray at his temples, the composure. And then, because Sandra Odom had spent 24 years in Houston and had been present in federal court more times than she could count, she recognized the face. She did not run. She walked. But her expression changed on the way over, in the way expressions change when a person realizes that a situation is far worse than reported. Not worse because of danger, worse because of gravity. The kind of mistake that does not get corrected with an apology. The kind that generates investigations, hearings, and institutional reforms. She reached Kowalski and stopped. She did not look at him first. She looked at Dr. Hayes. Dr. Hayes, I am Captain Sandra Odom. I am deeply sorry you are standing on this sidewalk. Dr. Hayes let the statement sit long enough for every witness to hear it. Then he said, "Thank you, Captain. I appreciate you coming personally." The certainty that had been holding Kowalski upright for the last 11 minutes began to dissolve. "Captain," this individual refused to comply. Odom held up one hand, not a dismissive gesture, a firm one. She looked at Dr. Hayes. "You have been here for how long?" 18 minutes. I was due inside at 9. It is now 9:17. Kowalski's radio crackled. The voice of the courthouse's chief marshal said, "Captain Odom, I am calling to inform you that Dr. Raymond Ellington Hayes is a court-appointed expert witness in the Whitfield Crane proceeding. His credentials were processed 9 days ago. He is on the federal judiciary's senior advisory panel for the Southern District. He is a retired judge of the Fifth Circuit Court of Appeals with 31 years of service. And Judge Hines-Batiste is currently asking whether she needs to come to the front entrance herself. Tell Judge Hines-Batiste that will not be necessary." Dr. Hayes' voice carried calmly toward the radio. "And please tell her I apologize for the delay. Think about what just happened." An officer who spent 18 minutes refusing to make one phone call just heard the answer to that phone call read back to him over a radio, in front of witnesses, on camera. All of it was one radio call away the entire time. If you believe the people who demand the most verification are often the least willing to do it themselves, hit the like button. Everyone tells this platform that stories like this one deserve to be heard. The radio went quiet. The crowd went quiet. The only sound was traffic on Rusk Street. Odom turned to Kowalski. Her voice was not angry in the way that shouts. It was angry in a way that was worse than shouting. Quiet. Final. Carrying the full weight of 24 years of understanding exactly how much damage one officer's bad judgment could do. "Officer Kowalski, do you have any idea who this man is?" Kowalski said nothing. She continued. "Dr. Raymond Ellington Hayes served on the Fifth Circuit Court of Appeals for 31 years. He authored the controlling precedent on unlawful detention in racial profiling cases that every officer in this district is trained on. He has been cited by the Supreme Court of the United States. He has been in and out of this building for 4 decades. And you stopped him on the sidewalk and asked him if he was lost." The silence that followed was complete. "I was following protocol. He was approaching a restricted entrance. The sign says federal court personnel and authorized visitors. He is both. He showed you a letter of appointment. He offered to have you call security. He gave you his name and told you to run it. And you told him you weren't scared of his speech. That exchange is on 2 cell phone cameras and your body cam. I will be reviewing all 3 before noon." Dr. Hayes spoke. "Captain, I need to get inside. I have testimony to prepare." "Of course." She picked up his briefcase before he could reach for it. She turned to the courthouse marshals who had come down to the entrance. "Please escort Dr. Hayes to chambers immediately. Please inform Judge Hines-Batiste he is on his way." Dr. Hayes paused at the entrance. He looked back at Kowalski one last time. His voice was not cruel. It was something more cutting than cruel. It was entirely calm. "In 1991, I wrote the majority opinion in Harmon v. City of Dallas. It established the standard for unlawful detention in cases involving racial profiling by law enforcement in Texas. It is, to this day, the controlling precedent in this district. You were detaining me under a standard I created. I want you to sit with that." He went inside. Consequences told too quickly feel like footnotes. They are not footnotes. They are the point. They are why a story like this matters, and the part that most people treated the way Dr. Hayes was treated on that sidewalk never lived to see. At 9:44 that morning, Captain Odom submitted a formal incident report to HPD's Internal Affairs Division. She filed it immediately, without consulting the union representative first. The language was unusually direct for a department document about one of its own. It noted racial profiling, age-based assumptions of incapacity, failure to verify credentials when explicitly offered, and escalation to detention threats without probable cause. It specifically noted that asking a subject who was speaking clearly and presenting identification whether he was lost constituted ageist discrimination, in addition to racial profiling. By 10:30, both cell phone videos were online. By 11:15, the Houston Chronicle had called the HPD press office and the courthouse. By noon, the video had 400,000 views. When Dr. Hayes walked out of the courthouse at 2 o'clock that afternoon, 3 local news vans were on Rusk Street. He did not stop for them. He sat in his Lincoln Continental for 90 seconds with his hands on the wheel, allowing himself exactly that much private reaction after 31 years of not allowing the personal to interfere with the professional. Then he called his son, a cardiologist in Dallas named Gregory. Gregory Hayes said, "Pop, we need to call someone." Dr. Raymond Hayes said, "I already know who to call." That afternoon he called Paulette Washington Raines, a civil rights attorney who had practiced for 37 years and won most of what she took on. She reviewed the videos, the incident report, and the notes Dr. Hayes had dictated into his phone immediately after the encounter, because that is the discipline of a man trained in documentation. She said, "Raymond, we file within 30 days. And did you know one of those cameras caught his body cam light blinking? It was on the whole time." "I assumed it was," Dr. Hayes said. "Good. Because that footage is going to say the same thing the cell phones say. And that is going to make this very simple." Kowalski was placed on administrative leave without pay 3 days later. The HPD statement used the words pending review 4 times in 140 words. It did not acknowledge racial profiling. It did not use the word ageism. Paulette Washington Raines held a press conference the following morning and used all of those words with great precision. The internal affairs investigation ran 11 weeks and 47 pages. It found 5 HPD policy violations and noted that Kowalski had generated 8 prior complaints in 6 years, 6 involving stops of black men over 55, 3 of which included questions about whether the individual was lost or confused. Every prior complaint had been closed with counseling. The report used the phrase pattern of behavior 7 times. The union filed a grievance. At the disciplinary hearing, the board asked the union's representative whether protocol included asking a subject if he was lost without any behavioral basis for that inquiry. The representative did not have a satisfying answer. Officer Travis Kowalski was terminated on the 90th day after the incident. The termination letter cited racial profiling, age-based discriminatory assumptions, failure to follow verification protocol, escalation without cause, and a documented pattern inadequately addressed by prior review. His name was submitted to the Texas Commission on Law Enforcement for decertification. His certification was revoked. He cannot work in law enforcement anywhere in the state of Texas. He had asked elderly black men if they were lost 8 times before he asked Dr. Hayes. 8 times the department reviewed it and found nothing worth stopping. It took the 9th encounter with a retired federal appellate judge whose name produced a radio silence the entire sidewalk could hear before the institution finally moved. The civil lawsuit was filed 31 days after the incident, alleging unlawful detention, racial and age-based discrimination, violation of civil rights under color of law, intentional infliction of emotional distress, and institutional failure to adequately discipline an officer with a documented pattern of discriminatory stops. One of the most powerful documents in the case file was a medical record. Dr. Hayes had driven to his physician's office at 4:15 that afternoon, after completing his expert testimony. His blood pressure reading required a same-day conversation with his cardiologist and 48 hours of monitoring. He did not require hospitalization. But the record said clearly in the language of medicine what Dr. Hayes had already said in the language of law. What happened to him on that sidewalk was not merely an insult. It was a physical harm. 18 minutes of sustained stress applied to a 70-year-old man's body, without justification, without legal basis, without humanity. The city's legal team reviewed the evidence. The videos, the body cam footage, the dispatch audio, the medical records, 8 prior complaints, and the internal affairs report that used the phrase pattern of behavior 7 times. They understood what they were looking at. A retired federal appellate judge, cited by the Supreme Court, who would testify in a civil courtroom backed by a civil rights attorney who had not lost a case in 11 years. They settled in 4 months, $11 million. The largest civil rights settlement in the history of the Houston Police Department. $11 million paid by the city, which means paid by taxpayers. Every resident of Houston paid a share of what it cost to employ an officer with 8 prior complaints who chose the wrong sidewalk. If you believe that number should appear on a public municipal budget the same way road repair and school funding do, share this video right now. Because it is already in that budget. It just does not have a label that makes it easy to find. Dr. Hayes did not hold a press conference. He submitted a written statement through Paulette Washington Rain's office. It read in part, "I did not bring this case because I was humiliated. I have been a black man in America for 70 years. Humiliation has been offered to me many times by people who did not know who I was and would not have behaved differently if they had. I brought this case because the officer who stopped me was the 9th black man over the age of 55. He had stopped with the same assumption. The department reviewed those 8 stops and decided 8 times that nothing needed to change. I was simply the 9th. The difference between me and the 8 men who came before me is that I happen to have a 31-year career in federal law and a civil rights attorney I have known for 20 years. That difference should not be what determines whether justice gets done. The point is that the next 70-year-old man who parks in front of a federal courthouse should be able to walk to the door without being asked if he is lost." The HPD announced policy reforms 6 weeks after the settlement. Mandatory implicit bias training renewed annually rather than once at hire. A requirement that any officer intending to stop an individual at a federal facility entrance first contact facility security before initiating that contact. Any complaint alleging age-based assumptions to trigger automatic supervisory review. A limit of 3 unresolved bias complaints before mandatory reassignment. These reforms were not given to the department. They were extracted from it. That is the accurate description of how institutional change happens, not because organizations recognize problems and correct them. Because people with standing, evidence, and the refusal to let it go make the cost of inaction higher than the cost of change. Dr. Hayes returned to his regular work. He still drives the Lincoln Continental. He installed a dashboard camera the week after the incident. Not because he was afraid, he told his son Gregory, but because documentation is the foundation of truth, and nothing that happened on Rusk Street changed his thinking on that. He still parks in front of the courthouse. He has not been stopped again. What happened to Dr. Raymond Ellington Hayes goes beyond the specific details of that morning. It sits in a place that people of a certain age understand in ways others may not. When you have lived 7 decades, you have earned something. Not entitlement, not special treatment. The right to be seen clearly, to have the evidence of your life taken into account before someone forms a judgment about you. To not be reduced, in a single glance, to an assumption so shallow it could not survive 10 seconds of honest scrutiny. And then a 29-year-old officer looked at him on a public sidewalk, and the first words out of his mouth were, "Are you lost? Not who you are. How can I help you?" The first assumption was not that this man was competent. It was that he was confused. That he had wandered. That he needed someone younger to sort him out. That is ageism. When it is applied to a black man, it compounds with racial profiling into something almost unbearably insulting to witness. The indignity is not just that he was stopped. It is that someone looked at a lifetime of achievement and saw nothing. Who looked at composure and read confusion. Who looked at authority and saw only age. There is a particular cruelty to ageism that sets it apart from other discrimination. With most bias, the assumption is about what you are. With ageism, the assumption is about what you are no longer. The message is that you are diminished. That the decades of experience and hard-won authority you carry have somehow become a liability. That the measured pace and quiet certainty of a person who has seen enough of life to stop being startled by it are signs of weakness rather than depth. Dr. Hayes knew exactly where he was. He stayed still. He stated the facts clearly. He gave the officer every opportunity to choose differently. That patience is not passivity. It is what comes from being through enough to understand that the loudest voice in a room is rarely the most powerful one. His calmness was its own form of devastation, because it was the calmness of a man who already knew how this ended. And he let the evidence do what evidence does. $11 million. 1 terminated officer. A revoked certification. Binding policy reforms. That is what happens when a system underestimates a man of 70 years, 3 decades on the federal bench, and the absolute knowledge of exactly where he stands. Eleanor Hayes, his wife of 43 years, agreed to answer one question from a reporter. She wrote, "Raymond has been telling people who he is for 70 years. He has done it with patience. I am not sure I could have maintained. The settlement is the system finally writing down what Raymond has known all along. It is late. It is not enough, and it is a start. Late, never quite enough. And a start. That is what justice looks like in practice. If you know someone whose story ended in silence, someone who was profiled, dismissed, or harmed, and never saw a day of accountability, subscribe to this channel and leave their first name and city in the comments. Stories that end in silence deserve to be spoken out loud somewhere. This is a place where we speak to them, and if this story reached you, if it said something you have felt but not yet heard, said plainly, share it with someone who will recognize exactly what was at stake on that sidewalk. Because they are out there, and they are waiting to feel seen,